screen. So thank you both for joining us to speak to your submission. We have you for 10 minutes this afternoon, so I'll hand over to you.
Don't jump out of the window yet,
much,
Sam.
and thank you to the committee for giving us the opportunity to present on our submission to the bill. I'd like to start with a few introductory comments, if that's okay. My name is Muriel Newman, and I was a Member of Parliament for 9 years. On leaving Parliament in 2005, I established the New Zealand Centre for Political Research, which is a public policy think tank. Given the importance of the coast to all New Zealanders, that's social importance, economic and national security importance, we've been following developments in the foreshore and seabed area for a very long time. Right back, from the time that the foreshore and seabed was held by the Crown on behalf of all New Zealanders, to the 2003 controversial Court of Appeal ruling, which essentially said that discrete pockets of customary marine title might still exist, to Labour's 2004 Foreshore and Seabed Act, and then the 2011 Marine and Coastal Area Act. And that, of course, allowed tribal claims if the claimants held the areas exclusively and continuously since 1840. But importantly, it guaranteed that public access to the coast would not be restricted. When the 600 or almost 600 overlapping claims flooded in on the eve of the 2017 deadline for the bill, for the law, we felt that we should get involved in the process to try and ensure that the law delivered on the promise that it had made to New Zealanders. So we raised the funding and we supported 2 community groups to lodge notices of appearance on all of the claims. We wanted to give a voice to recreation users, so we supported the Council of Outdoor Recreation Association of New Zealand, and a voice to property owners, so we supported the Landowners Coalition. And as a result, over the years, we've been involved intimately in 2 High Court cases, 1 Court of Appeal case, and the Supreme Court case is scheduled for next month. And it's very clear to us that the law is not delivering on what Parliament intended. So we strongly support the law change, and we'd like to take this opportunity just to make 6 suggestions to improve the law, and I'll just run through very quickly what they are here now. First of all, we believe there should be a public submission process in the whole High Court claims process to ensure that judges are better informed. Such a process is built into the direct negotiation process with the Minister. And, the High Court process is adversarial, and it was thought that a lot of community groups would involve themselves in it, but the costs have ruled most of them out. As we know, claimants got up to $458,000 to prepare and present their claims, but anybody opposing the claims got nothing. So we think that the Attorney General should set up a little process to allow public submissions on each of the claims so the judge is better informed to make his rulings. Secondly, we believe that tikanga should be removed from the law. The problems with the Act that arose are mostly because the judges looked at the tests in the law through the lens of tikanga. And now the tests have all been tightened. It really means that tikanga is less relevant. And I think to make sure that the law doesn't go off the rails, it should actually be removed entirely. We also believe that wāhi tapu should be removed from the law. Wāhi tapu hasn't become an issue yet because that's the second stage of the claims process. First, customary marine titles are awarded, and then those title holders are asked to present their wāhi tapu claims to the court. At that stage, it probably will be extremely controversial. But by preventing public access, wāhi tapu, they're inconsistent with the guarantee that public access would not be restricted. And that was a promise that was made by Parliament.
She doesn't know what a wāhi tapu is.
Next, we removed that shared exclusivity and joint title should also be removed from the law. The Attorney General, when responding to those hundreds of claims that flooded in, initially stated that overlapping applications were inconsistent with claims of exclusive use. And we believe that what's happened is that the idea of shared exclusivity and joint title has been introduced by judges into the law to circumvent the actual fundamental right or issue that was presented in the law, which was that you can only gain a title if you have exclusively used it without anyone else being involved. So we believe that it should specifically state in the law that shared exclusivity and joint applications should be removed. And to avoid any doubt, we believe that any new application lodged after the 3rd of April 2017 strict deadline should be ruled out. Next, we remove the provisions relating to resource consents and mining royalties should also be removed from the law. Nobody envisaged that there was going to be so many claims. A previous minister reckoned it was going to take 20 or 30 years to resolve.
How many shares is that she owns in the mining companies?
So asking resource consent applicants to consult all
of how much money does
claimants
she take from them?
is just totally unreasonable. Sometimes there's 20 or 30 claimants in an area. And similarly, withholding mining royalties from the Crown for that length of time, again, is totally unreasonable. And just finally, given the magnitude of the problems of interpreting the law, in spite of the clarification that's in the bill, we strongly recommend the inclusion of a review period so that after a short period of time, the Crown can have a look and see whether the law is delivering what it intended. So that's essentially what we presented.
Probably the
and
only
I'm happy to
sensible
take
thing
questions.
she's said.
Thank you, Dr. Newman. We've got the first question from Takutai first.
Didn't agree with Dr. Newman.
Sorry.
I know there's a lot of things you think should be taken out, and that's great by. Everyone is welcome to their opinion. How do you think that the law, the proposed one, should give effect to Te Tiriti o Waitangi? Very, very simple statement. Very simple question. How, if you think that things like tikanga should be taken out, wahi tapu should be taken out, shared exclusivity should be taken out, these are all things that the Māori partner to Te Tiriti o Waitangi live by. So my question for you then is, how do you think that Te Tiriti o Waitangi should be embodied or given effect to in the proposed law? The
Marine and Coastal Area Act contains reference to the Treaty of Waitangi. We're not suggesting that that is touched, so that can stay where it is. But what we are saying is that the reference to tikanga, because it is new to New Zealand law, it actually meant that the judges were not able to ascertain that there was a second test in the law. There was tikanga and there was the test of exclusivity. They totally ignored the test of exclusivity, and that's the High Court and the Court of Appeal, in terms of the way that it was written, in terms of what Parliament wanted. And so it's ended up by causing the trouble that we're trying to fix now. And in terms of Waihi Tapu, as I said, we haven't gotten on to Waihi Tapu yet in the Marine and Coastal Area Act. That's coming. And so I think in practical terms, both of those things could be removed. It won't affect the actual way the law is structured, but it will make it a lot easier for the law to go ahead and for people to either, get their claims or not, depending on how strong their case is.
And so you think that that's a reasonable embodiment of Te Tiriti o Waitangi?
What's that? Sorry, I didn't catch.
Oh, sorry, yeah. And so you think that that's a reasonable embodiment of Te Tiriti o Waitangi?
I'm saying that the provisions for the Treaty of Waitangi in the Act, we're not talking about those at all. They would stay as they are.
Okay, thank you. We've got 30 seconds left. Dr. Newman, with your indulgence, I think that may be Frank beside you, who will be preparing to be the next submitter. With your indulgences, I'll take a question from Duncan Webb and run a little bit overtime in this session. Is that okay?
Yep.
Thank you.
Dr. Webb.
Thanks, Mr. Chair. Just curious on your views of shared exclusivity and whether you accept that people can jointly occupy a space exclusively. Are you happy with it? I mean, is that something that you're comfortable with?
Well, no, this is the problem. The original law suggested that if somebody had held an area of the coast as if it was their own, which was the basis for them being able to claim the customary marine title, they had to have used it without anyone else encroaching on it. And this is where the judge in the High Court case, in the Edwards case, we believe made a fundamental error by saying because all the claims overlap, then we'll just grant a customary marine title to them all to be shared. And the Court of Appeal went down that track as well. And that's wrong.
Isn't the case that you yourself occupy your house with the guy who's sitting next to you exclusively and jointly?
Yes, got him.
Yeah, but that's different, isn't it? That's a joint property right.
Well, and there we have it, because we are talking about property rights.
No. The original law was said that the claimants must have held it exclusively and continuously without substantial interruptions since 1840. Now, to most people, exclusively means one tribal group owned it and not a whole bunch of them. If they'd have wanted a whole bunch of them to have owned it, they'd have put it in the law.
That's your overlay. Joint ownership is recognised in every legal system that I'm familiar with. Thanks for that.
I actually did jointly own it from the outset. I didn't come in lately and claim half.
Okay, thank you all. What we'll do now.
Walk into the spider's web with that one. Holy shit, that was a good setup.
This doesn't surprise me from a former ACT MP, and I've been doing a bit of reading. I didn't know before she ended up as an MP, she worked at Michael Hill.
Yes.
I would not have known that.
It's so funny because they're getting so tied up on what shared exclusivity means. Like, they forget the fact that hapu belong to an iwi, and iwi descend from a waka. One waka, one iwi, lots of hapus. You know, it's like, oh, okay, it makes sense to share, doesn't it? We share one title.
I wonder if she's one of these people who believes that was it on a bus there is seat exclusivity.
Yeah.
The only exclusive seat on a bus is known as the driver's seat.
Yep. Can we talk about waihi tapu as well? It's like, come on. Look, lots of waihi tapu are available for the public to go and visit and see, okay? There are limitations of what you can do there. Like, for example, I live down the road from a waihi tapu. It's called Pukaha. No, you can't start a forest fire. You can't go camping there. I'm sorry. You can't disturb the kōkako that are flying around in the bush. But you can still go there and you can still enjoy the bush. No one's stopping you from doing that.
Sounds like you're sharing an exclusive activity.
Yeah.
Oh, man.
This whole thing about exclusiveness. God. But yeah, it makes it out like, you got exclusive rights to...
That was an object lesson of intolerance, that was.
It's just stupid.
Intolerance of a different worldview, a different way of being. And it ties in with what we saw with Don Brash, which is, we are one, but actually everything gets atomized to the individual and to the singularity. And it's just like, no, that's not the way people work.
Yeah, and also too, oh shit, I forgot my thought. There's just so much there to cover. I'm sure will come back to me.
One of the things that occurred to me while she was going through it was that, courts don't deal in fantasy. They don't invent stuff. They look at the evidence in front of them and they reach conclusions and determine which way they go. So
yes, I remember the points.
For them to have arrived at share exclusivity, it must have come from somewhere.
Yeah.
So they didn't just invent it.
No.
This is not a court fiction.
And also the false premise too that they're operating from. This is the point that I just remembered. They think that the majority of rangatira signed the English version of the Treaty of Waitangi. They did not. They signed Te Tiriti. So which have different things within that.
But they also signed the preamble to the treaty.
Yes.
And the preamble to the treaty is the context of those three articles.
Yes.
And if you just forget the preamble as it's only preamble, then the treaty loses its its full meaning, and you read the preamble, then you read the 3 articles, and you go, aha, I see what was going on here. You know, it was purely a recognition that actually our lot of scoundrels, and we need to have our laws for them. You guys, we want to protect you from them. So let's do it.
Sound like a broken record here, but I wonder how Muriel would fare on Judge Judy.
Probably not well.
Yes. But the other thing was that Ferris got stuck into him, and it's not Ferris's. That's his last name. Yeah. No, but he talked about is what you're talking about sufficient for Te Tiriti o Waitangi to be given effect to, and she talked about reference but not given effect to. So she said we're not talking about the reference parts to the treaty, but that's not giving effect to the treaty by the way the legislation is constructed, and also by the way that the consultation for it's taken place. The question is what consultation, and it goes back to that relationship question. This is
by the time they put the ad in the paper, the consultations have already closed.
Yes, done. I know. Yes, it's yeah.
I mean, the Waitangi Tribunal said it themselves. It's like that's one of the breaches that the Crown did. They didn't consult Māori.
Didn't consult.
Yeah.
Yep.